General, appearing on behalf of the appellants. The issue presented in this appeal is whether the BankShot video game is an illegal gambling device. The district court determined that some aspects of the BankShot game were illegal, but found the game was not illegal in its entirety. The district court erred in two key respects. First, it erred in construing the statutes prohibiting gambling by use of a gambling device to mean a device is illegal only if it involves betting on the outcome of a game determined predominantly by chance, when the plain language of the statutes requires only that the outcome be determined by an element of chance for a device to be illegal. Second, either an element of chance or predominance of chance standard. The district court erred by not finding that BankShot in its entirety is an illegal gambling device.
What statute are you referring to as to the predominantly versus the whatever that standard is? I can't remember. It's
not in statute, Your Honor. That's our position. The statutes actually that define gambling and gambling device, those definitions are 281101, 4, and 5.
And what is the basis of your opinion?
Our basis is simply the plain meaning of the statutory language. It says that it applies, gambling involves betting on a future event whose outcome is determined by an element of chance. Nothing in the plain language of the statute suggests that that means predominance or dominance of chance.
But
now, there is prior...
Hasn't the department for many years, up to and including the beginnings of this case, construed the current statutory language as preserving the predominance test?
First of all, the department actually isn't responsible for enforcing the state's criminal gambling statutes. So the principle that an agency construction can be utilized where the agency has the authority to enforce the law in order to interpret the statute really doesn't apply to the department.
Well, isn't there evidence in this case that a representative of the State Patrol told the BankShot interests that the predominance test was the law of Nebraska, and that's how the game would be judged?
Officer Luttrell did tell that to the game's developer, but again, he's an officer with the patrol. Is he an executive who can make the type of administrative interpretation that is subject to the rule that that's a binding administrative instruction?
Well, is there some element of due process in this? Notice and an opportunity to be heard?
Your Honor, if the statute is clear on its face that an element of chance where betting is involved on the outcome is in fact gambling, and when it's used, when a machine is used, that's use of a gambling device.
Well, if it's so clear on its face, why is the department and the State Patrol and everybody else interpreting another way?
Well, they have...
I mean, I understand your argument, but I'm not quite as certain as you are that the statute is that clear on its face.
Well, again, applying the plain meaning rule, you really don't look at extrinsic evidence to interpret the statute when it's clear on its face. That's the Emeritus versus Balka case. I don't deny that the departments, in this case, have obviously taken that position, but here we're presenting squarely to the court the legal issue of what is the proper interpretation of the statute, and an agency construction cannot obviate the plain meaning.
This would be a fairly significant change in the law, would it not, to construe the statute as you now contend that it should be construed?
There's no question that it probably will have consequences well beyond this case. And I think if you look at the two cases we cite in our brief, the Iowa and New York cases that interpreted similar language, the New York court recognized that. Maybe it goes farther than the legislature would prefer to go.
Would this prohibit pinball machines?
Well, of course, in Madero, the court determined pinball machines that provided free replays were illegal devices. So under either standard, actually, pinball has been determined to be an illegal game under even a predominance test in Nebraska.
Would this definition that you're proposing or this standard be applicable in every type of proceeding that could involve a potential gambling device? Revenue, criminal?
Well, it's a criminal statute, so it would apply in that context. Now, we certainly recognize that probably is an extension. What most people understand is the meaning of the statute. But it hasn't really been tested or decided by this court what the current statute means. There was a time prior to 1979 when the statute simply said game of chance, and that's the language used in the Constitution. And the court judicially construed game of chance to mean dominance or predominance of chance in outcome determination. But the history of the statute we submit shows a change from that. It says only an element of chance is required, and that's different. There's nothing indicating that dominance of chance is the standard. And other states have addressed that with respect to amusement devices by saying we'll allow legitimate skill-based amusement devices, but we will limit the prize that can be awarded to, say, $5 or $10 not payable in cash. And that discourages an attempt to try to disguise an amusement device from an illegal gambling device, which we think is what we have in this case. Assuming even that the predominant standard applies, BankShot is a legal gambling device in its entirety. The court found the game was not predominantly chance in what's called the spin mode of the game. There's video depiction of play of the game in Exhibits 175 and 211, and we strongly urge the court to review the video because it's really necessary to get a full understanding of how the game is played. But there are two key reasons we submit why even in the spin mode of this game, it can't be determined primarily by player skill if that is in fact the standard. One is the speed of presentation, and the infrequency of winning outcomes that are made available to the player is the second factor.
But was there a dispute by the experts on that conclusion, whether it was...
There's no question their ultimate opinions differ, but, and it's not possible to address all of that here, but if you look at...
So what is our standard of review then?
It's de novo both as to factual and legal issues because we're dealing with an equity action, declaratory and injunctive relief. But what's key is both Dr. Deffenbacher, the state's expert, and Dr. Green, plaintiff's rebuttal witness, both agreed that a normal person would require a viewable pause time of about 500 milliseconds to perform the human reaction time task presented by the BankShot game in the spin mode. American Amusements' own video tests of the game in the spin mode show display times that range from 470 milliseconds for the first puzzle, and that decreases down to 370 milliseconds for the ninth puzzle. While they claimed an additional 80 milliseconds of viewable time, even under that scenario, the game would be too fast for most players after the first few puzzles. But beyond that expert testimony, we'd like the court to look at the frequency of presentation of winning outcomes, meaning outcomes that pay more than the player's wager. To understand that, you have to know how the outcomes are presented. Now, under the current software, the combinations are presented to players from three tables that contain a predetermined pool of outcomes, pools A, B, and C. There are 10,325 outcomes in each pool. The first combination is taken from pool A. If the player doesn't stop there, the second combination comes from pool B. If the player doesn't stop there, the third combination and all subsequent combinations come from pool C until the player stops. The number of winning combinations, which award a prize greater than the amount wagered, falls off drastically after the first two combinations. In pool A, 1,187 out of the 10,325 combinations are winning outcomes. That drops to 155 in pool B and drops further to 12 in pool C. So we submit that pure chance will determine if a player is presented a winning outcome to select from the first two displays in pools A and B. Only one comes from each pool.
Could an individual that plays this a lot come to realize that A is a better odds?
The game certainly doesn't tell them that, and I don't know that the record reflects anyone could, in fact, determine that.
But a player with a significant amount of patience could simply wait until he or she sees combinations in the correct color to yield the amount of points that's necessary to have a winning puzzle.
Based on the infrequency and the speed of the game, we don't believe that's correct.
But doesn't the player control which puzzles he or she wishes to solve?
they can stop at any time. But again, when the outcomes are so infrequent where they can actually win, we submit that chance really is a predominant factor. And more importantly, I
I'm
think
sorry,
if you look
so
at
you're
the
saying
jackpot,
you can't gain skill here by observing patterns if you're willing to put in enough
not to
money.
actually hit the winning outcomes. No, and the jackpot is the perfect example. It's inserted after 144,500 or 433,650 puzzles. That can take over 46 hours or 140 hours before that potential
But that's in
puzzle.
a different mode, is it not, than the spin?
No, it's in all game modes.
Okay.
It's in a separate pool, the jackpot pool, that's inserted in the other pools. But it can take 46 or 140 hours for that may even appear. Now, obviously, no player can sit there that long. It can't be skill, but chance that determines the jackpot outcome.
If a player tires of waiting but does not stop the game, they've not lost anything, have they? If they simply sit there for half an hour, don't see a combination that they like, and therefore don't stop the spin or the whatever mode it's in, they haven't lost anything.
Well, they've never finished the game.
But, but they
Well, I don't know if it's possible. I suppose they could redeem whatever credits they have, even if they just put the
That's my
money in.
question.
That's correct.
Yeah.
But again, clearly, we believe under that scenario, the jackpot outcome can't be determined by skill. It's
What's
just
the
not.
status with respect to the court's ruling with respect to the fast mode?
The court didn't make a decision one way or the other.
So what are we being asked to do with respect to the fast mode, if anything?
We would, well, in actuality, the fast mode has been eliminated from the game. I think counsel for the plaintiffs and appellees can confirm that. But if necessary, we would submit that that mode also is clearly one in which chance predominates over skill.
Thank you.
I see I've run out of time, so thank you.
Thank you very much. Mr. Colhane, good morning.
Good morning, Your Honor. I wanted to begin by addressing your question, Judge Gerard, about whether there's any aspect of due process that is implicated here. I don't know if due process is implicated here, but basic fairness is. The record demonstrates that John Fox, the operator of American Amusements, set out to make a skill-based amusement device that would be something that could be utilized within the laws of the state of Nebraska in bars and restaurants and places where people like to play those games. He was very open and above board about everything. The first aspect of this game the first game that he developed, he invited the State Patrol, Officer Luttrell, in to look at it. Officer Luttrell looked at it, he played it, he told them what the standard was, predominance. He said, there's some changes I think you should make to be sure that this complies with Nebraska law. Those changes were made. Then, at the suggestion of the state of Nebraska, it was sent to 3 different testing agencies that specialize in analyzing games and applying the legal standards to determine whether they comply with those standards. All 3 of those agencies came back and said that it was predominantly a game of skill. It was at that point that the state of Nebraska apparently decided that they needed to change the standard if they wanted to outlaw this game. And they started applying this predominantly a game of they wanted to disregard the predominance and argue that if there was any element of chance that determined the outcome, it was illegal. Now, we think that is not only inconsistent with prior Nebraska law, but with the current statute. The key word here is determined. The statute involved is 28-1101, subparagraph 4. And the section that you need to, the phrase that is referred to in the statute is simply this: which outcome is determined by an element of chance. And I think determined is the key word here, because determined means decide. If you look up the dictionary definition of it, it's what element determines the outcome of the game, what decides the outcome of the game. That is, in essence, a codification of the old standard announced in Badero, which was that the issue is what is the predominant aspect of the game, skill or chance. I wanted to also address your question, Your Honor, because this goes along the lines of what I was saying before to Judge Gerard. Once the judge ruled in this case, even though the judge did not rule on the fast mode, that's been eliminated from the game. The game as it currently exists complies completely with the judge's ruling.
So
what he said was legal.
So we're not concerned in this appeal with the ruling with respect to the slow mode or the fast mode? Is that your take on it?
That's correct, Your Honor. We did not cross appeal. as to the ruling on the slow mode. And I don't know that it's in the record, it probably isn't, but I'll represent to the court that the fast mode has been eliminated from the game. So what the game is currently configured has the spin mode, and the bonuses, the pools that the judge found were too difficult.
We're being asked to address the spin mode ruling only.
That's all. That's what
Okay.
the court found was legal, and we did not cross appeal as to the fast or slow, either of those other rulings. The only issue is the spin mode. And when you look at the spin mode and you apply the standard that the state said was to be applied when this game was developed, which is the predominant standard, I think it's pretty clear that skill predominates in this game. And probably the easiest way to do that is to compare it to things that we know are purely chance-based. And a good example in my mind is Keno. You know, a person goes into a Keno parlor and all they have to do is be able to fill out the chit. And then they pay their money and sit down and wait to see what numbers come up. They have nothing to do with how those numbers are selected, what numbers are selected. All they do is look at their card, and if their numbers come up, they win.
But Mr. Bartell would say it's nearly impossible because of the speed and infrequency for anyone to win.
Well, there's two interesting aspects there. First of all, the nearly impossible aspect is just totally refuted by the evidence. The evidence here is that during the time this game was in operation, about 2.5 years before the trial, there was about $70 million in total credits played on these machines. Those credits were played based upon $16 million of money actually put in the machine.
But did those credits exceed the wager?
Exceed the wager.
Right.
Basically what it means is people won 5 times as much as they deposited and then replayed those back. I'm not saying that those were not reused, but much like the games where you win free games. Once the credits are added in, they can play those just as if they had put the money in the machine.
So was there conflicting expert witness on whether it's chance, an element of chance, or whether it was skill?
There clearly was, Your Honor.
All right. Well, what was your experts?
I was going to say it's conflicting may be a misnomer because the state's expert based his opinion on playing the game 40 times at Clancy's Bar in Omaha.
That's Dr. Deffenbaugh?
Dr. Deffenbaugh.
Right.
And he admitted that when he played the game, he didn't even understand how to play it. He didn't read the help menu. He didn't even understand how the game worked. For example, at its most basic, he did not realize in playing the game 40 times that the same number was always associated with the same color ball, which is kind of key to playing this game. And the early...
Was there testimony that a player paying attention could stop looking at numbers and just key in on color?
Absolutely. And in fact, that came from Professor Green, the gentleman that testified for American Amusements. Now, he actually did testing, and some significant testing in this machine up in Minnesota, where he is a professor in the Human Factors Department up there, basically a cognitive learning department. And he testified just exactly that the way to win this game and the way to play it successfully is to concentrate on colors, not numbers, because it's much easier to recognize colors than numbers. And that after just playing it 2 or 3 times, the subjects that he had playing the game realized that there was obviously a connection between the number and the color and that it was always the same. Also happens to be the same numbers that appear on any pool ball, so anybody that's played pool for any amount of time recognizes that. He testified that it was not only possible, that it was easily done, that you could recognize and win this and successfully solve these puzzles within the time allotted. Dr. Deffenbacher's problem is his whole testimony is based upon software timing. In other words, the timing that's written into the software, when all the evidence was that was kind of like a model. That was not what actually occurred, because what actually occurred was dependent upon the machines that as they operated. And Dr. Green tested those and actually timed them. So yes, there was conflicting
The timing is set by the software?
The timing is set by the software, but the pauses or the increments for that timing as shown in the software is not reality. I guess that would be the way to say it. The timing actually depends upon the machine as it's configured and the hardware that operates that machine. And that's where you get this 0.8.
So certain colors come up more frequently in a spin mode than others. It's
Absolutely.
green, and I can't remember the other one. So
Absolutely.
what does a player do? Does he look for the colors of green? But that doesn't pay. The greens don't pay off very much.
That's right.
So
Yeah. The skill is this. You definitely want to sit there and wait until the right patterns come up. And these things go like that. I mean, you know, every second and a half or so, you're seeing a new puzzle if you don't play it. Okay.
So if you do that, and if you put, say, $20 in, and you sit there for a half an hour, and you never see the color combinations that you're looking for in order to yield the points that you want, and you decide, I'm finished, what happens to the $20?
Well, you get most of it back if you want to. Okay, when I say most of it, before you start seeing the puzzles, you have to select whether you want to play for a quarter or 50 cents or $1 or $4. So if you put in, I want to play for a quarter, you can stand there for half an hour. If you never play a puzzle and you cash out, the quarter stays in the machine. You get $19.75 back. Yeah. So definitely you can, part of the game is no question there's patience to it.
So you don't do anything, it just charges you for one game.
What's that?
If you don't do anything, it just charges you for one game.
And at whatever price you selected to play for one game. That's correct.
Seems there's kind of an inverse relationship here. The less of a life you have, the better player you are.
Could be that.
But
Could be
it's
that.
still skill-based, is what you're
But you know, I mean, other aspects of this demonstrate that it's clearly skill-based. For example, one of the arguments that the state has made that I find totally incongruous is they had Dr. Deffenbacher testify that consumption of alcohol will degrade a player's ability to play this game, to select the puzzles as quickly as he can. Well, what game of skill isn't degraded to some extent by the use of alcohol? And conversely, what game of chance is degraded by the use of alcohol? You can drink as much as you want and play Keno, and you're going to have just as much a chance of winning Keno as if you were sober. So I think that clearly the standard here should be predominance. I don't think this court's ever backed away from that. I didn't get a chance to talk about the Contact Inc. case, but that is another section of the statute which this court applied that predominance standard, and it's kind of a reverse because in that section chance is required, and of course it said that the predominant standard applied in determining that. So
I'm sorry, repeat again the statute that you believe is on deck.
28-1101 subparagraph 4.
And that would be the scope of the ruling in terms of the standard.
That's the standard. That's correct, Your Honor. Yes. Thank you.
Thank you very much. Do we have time for rebuttal? There is no time for rebuttal. We will go on to in re interest of Lakota Z.